you've got to ask yourself, where's the legal risk line as an employer? And this applies to anyone, any business. Poorly handled processes create overlapping risk employment claims, injury style compensation pathways. The key theme that we see is process discipline, fairness, documentation, tone, supporting, timing, record keeping being imperative. And that's often something that we see happening as well in terms of crossover between other types of civil litigation and personal injury.
As an employer, now of course I only act for employees, but I am an employer, and you have to be very, very cautious and careful in the way you manage someone's performance. I've seen countless times in my career clients developing psychological issues due to poor management of performance by their employers. Now, an employee is entitled to investigate your performance. And ultimately, the question is whether that investigation is done reasonably, whether the management action taken by the employee is reasonable management action taken on reasonable grounds and in a reasonable manner. And if the answer is yes to any of those, and your condition wholly or predominantly is sustained, the psychiatric injury is wholly or predominantly sustained by the management action that's been taken reasonably, then unfortunately there is no entitlement to compensation. There's a specific exclusion under Section 40 of the Work Act, which disentitles people to compensation in circumstances where their mental injury has come about in that way. It's awful because, well, no one wants their performance to be investigated, and it's a horrible thing to go through. But you are not entitled to compensation because you're upset at the process of the investigation and the management action.
And, you can also see it from a different perspective as well. We often see that Section 40 being misused by insurers to simply reject claims broadly where they're legitimate claims as well, don't we, Sash?
Oh, we certainly do. We certainly do. Section 40 cases are very difficult to defend. I mean, they're difficult for the injured worker as well, but they're particularly difficult for employers to defend. Often people do the right thing by their employers, and employers need a very good reason to investigate an employee's conduct. Where we see the defence falling short is in circumstances where they've not followed due process. Or during performance management meetings, the managers involved are not being professional. The employee is not being provided notification of the performance issues. They're randomly called into a meeting, and say, the manager comes and says, "Hey, Mike, need to have a chat. Come in." They go in. All of a sudden performance issues are being raised, they're being yelled at, they're being screamed at, and the employee is just in shock at what's happening. Even if there is a legitimate basis for calling this interview with the employee, there is a way in which that interview should be conducted. And they're denied procedural fairness. So that denial of respect, professionalism, procedural fairness enables us to then argue that this process was not reasonable management action.
Yeah. And, it's a great example. And I often turn to think as well, what claims, what issues usually get run in the circumstances of the crossover of litigation, commercial, other civil with personal injury. And without getting technical here, what are the legal levers you actually pull? And the common ones that I think of are statutory consumer claims, ACL issues where product services cause harm. Then you've got negligence, duty breach, causation loss is the usual framework. Contract-related issues, what was promised, what warning terms existed, who owed what. Then you've got insurance coverage fights, who pays, which policy responds, exclusions, notice issues, other statutory issues relating to insurance and coverage. And then you've got other things like multi-party liability, which we've discussed at length, where everyone points at everyone, and then you've got issues around contribution or apportionment, which two different legal principles. So, yeah, it's not necessarily either commercial or injury. It's often, running both in parallel. And we've touched on that earlier, that they can often run parallel, and sometimes they can start as a personal injury claim and morph into a commercial or a parallel claim, or it could start as a commercial claim and morph into a personal injury claim, or they might split out. They might be run in different jurisdictions for different reasons. And so it's really a matter of keep continuing to review the case as it progresses, as evidence comes to light, as discovery or disclosure occurs, further instructions from your client, documents come to life, other witnesses come to life. And by that, it really helps you, assess the case on an ongoing basis, because you really want to do the best you can for your client's interest, don't you?
Exactly, exactly. And often through discovery, we're able to identify any other prospective defendants that are involved. Of course, we want to make sure that the proceedings are issued against everyone responsible for our client's injuries. And so, from that point of view, it's important to, in terms of maximizing our clients' benefits and entitlement to damages, that all people responsible for their injuries are included in the proceedings.
Yep. Identifying the right defendants and identifying all the defendants, whether it's possible at the beginning or if it comes out with time, as you say, through the procedures of the court or the jurisdiction you're in, that you join those parties as they become as it becomes evident that they are probably liable or to some degree in the matter. So I totally concur with that. I think that's a very important point. Identification, constant review of who are the parties to the proceeding, and also removing parties, not just joining, but removing them where they're not appropriate party to proceedings. Remove them early, avoid the cost risks.